Good afternoon and welcome everyone. Firstly, I wish to acknowledge the traditional owners of the various lands on which we stand today and pay my respects to their elders past, present and emerging. Great to have you with us today to show your support for sexual violence awareness and prevention and be part of our discussion on legal reform. As you know, October is Sexual Violence Awareness Month in Queensland, and our agency always organises activities to engage the community and raise awareness during this time. You can check out our Facebook and Instagram to keep informed about what's happening. This October, we are continuing with our Start by Believing Australia campaign, which was launched last year as part of the broader global campaign. Start by Believing is based on the simple tenet that when someone tells you that they've experienced sexual violence, you start by believing them. And if you start by believing that you can, in fact, make a positive impact on their healing journey. During our campaign this year, we're exploring a number of individual and system responses where it's really important to start by believing, and we have a particular focus on justice and legal responses. Every week, every Thursday during October, we have a Thursday Speak Out scheduled. Last week, some of you may have been part of the Clementine Ford Speak Out on affirmative consent. And today, Julie Sarkozi is joining us to speak out about legal reform, which is a hot topic in Queensland at the moment. I'd now like to introduce our special guest, Julie Sarkozi. Julie's a lawyer working at the Counselling Notes Protect service located at Women's Legal Service. The service provides representation, information, task assistance and advice to victim survivors of sexual assault whose records are being sought by a party in legal proceedings. Julie's been actively involved with advocating for survivors of sexual violence for many years, since the late 80s in fact, and has more recently specifically been seeking amendments to the legal definitions of consent, the application of mistake of fact, and a whole-scale review of the criminal justice response to sexual violence in Queensland. So to start things off, Julie, can I ask you to give a little bit of background around what's been happening in Queensland over the past year in relation to sexual violence law reform?
Thank you very much, Diane. It's a pleasure to be here today during this Sexual Violence Awareness Month, and I'm honoured to have been invited to speak on these topics. For the last couple of years, and I say this because there was a very prominent Four Corners report a couple of years ago, in which a survivor who had gone through the criminal justice system, a young woman called Saxon Mullins, had participated in a Four Corners report about how the legal system had responded to her complaint of sexual violence against a person who raped her down in New South Wales. And what was really interesting about that case is that it really did look at and focus on definitions of consent, and especially the accused's belief as to whether or not she was consenting. So certainly these issues around consent and, in fact, mistake of fact are not peculiar to Queensland. But as a consequence of that episode of Four Corners, there was some appetite amongst media to record and report on what each of the states' position was on these issues. There was also a very big review by a university down in New South Wales in relation to incidents and responses to sexual violence down there. And what the response really was from both, I think, Victoria and New South Wales, was that the government instigated a reform or review, into both of those states' legal responses to sexual violence, in particular their consent laws and other ancillary laws that are often work in conjunction with the consent laws and the rape laws. So because of that media interest, Queensland was also part of that, and Women's Legal Service and other stakeholders in this space, including the Gold Coast Centre Against Sexual Violence and other very prominent people like Bree Lee, who wrote Eggshell Skull, academics, Heather Douglas, Jonathan Crowe. We were all saying that the Queensland consent law application of mistake of fact, and in fact the whole Queensland response, criminal justice response to sexual violence, needed reviewing and needed change, essentially, needed to change.
Okay, and so as a result of that interest in reviewing and reforming the law, can you tell us about the state government's position in relation to reviewing and where we're currently at?
Sure. So some time ago, it was last year, the Attorney General referred the definition of consent, the mistake of fact, and some other laws to a body called the Queensland Law Reform Commission. And in that referral, the Attorney General said a range of things, but essentially, can you please look at these laws and how they operate and make some recommendations for review and reform if you think that that is actually necessary. So in, I think it was July or June of this year, that report and those recommendations were actually tabled to the Attorney General. And what they essentially say is, look, they say a whole lot of things. It's a very, very lengthy report. But what I would say is that it doesn't actually put survivors of sexual violence in Queensland in any better position than they may have been before those recommendations. So that's very, very disappointing given the level of public interest and also academic and other key stakeholders' interest and advocacy to change the laws. So essentially what the Queensland Law Reform Commission did was make some recommendations. The effect of those are to make very, very minor inclusions into our existing law that do not have any practical effect in terms of moving and progressing this community's legal definitions of consent and the application of mistake of fact. And I can sort of flesh that out a bit more.
Sure. Thanks, Julie. And I guess the recommendations then became drafted into a bill that is currently with the Parliamentary Committee on Legal Affairs and Community Safety. So we've ended up with a bill that has taken on board some of those very minor changes. Would you like to comment on how you feel about the bill in terms of going far enough, particularly in relation to consent and mistake of fact?
Certainly. So what we were arguing for and what we were submitting is that, say, for example, that the definition of consent should actually include or should reflect an affirmative model of consent. And what that means is that the definition should include the term agreement. And the reason why that is because when a jury is asked to consider whether or not there's any evidence of consent, what they are currently able to do is infer that consent could have been given even though the complainant or victim did nothing. Now, from our point of view, from the Women's Legal Services point of view, and also from many other advocates for change, that is just simply not good enough. And it is not good enough because all of the sociological and neurological evidence shows that one of the very common responses to fear, to threat, to danger is to freeze. So obviously, by extension, it means that when somebody is in a situation where they are going to be sexually assaulted or raped, it is very ordinary for their response to that to do nothing. And as our existing law operates, that means that that can actually be inferred as actually giving consent. So what we were hoping for is that the actual definition of consent would include the term by agreement, so that there would actually be a necessity to show in evidence what the behaviour of the person, of both people, was in relation to positively indicating consent, either by behaviour or words. So what in fact happened, and I'll have to turn down and read, is that the bill proposes an inclusion in the definition of consent to the following: a person is not to be taken to give consent to an act only because the person does not, before at the time the act is done, say or do anything to communicate that the person does not consent to the act. Well, aside from that being a very wordy and cumbersome sentence, what that actual amendment really says is that the actual court or a jury can infer, like is allowed to infer, that if somebody does something, then they may not have consented. We just don't think that that's far enough. Aside from it being a very, as I said, cumbersome way of saying that, it isn't far enough. How can we be in a situation where the jury is, the only thing the jury is allowed to do now is actually infer that, oh, well, they didn't do anything, so maybe they did. So that's just not far enough by any stretch of the imagination. I'd like to point out to the listeners that Tasmania's definition of consent says very clearly, no consent where a person does not say or do anything to communicate consent. That's the sort of definition that we wanted. Another example is in Victoria, where it says no consent where a person does not say or do anything to communicate consent. Again, very clear. Instead, we get this watered down. If somebody doesn't say or do anything, then maybe they didn't consent. So moving on to mistake of fact, or the mistaken belief as to consent. We are asking, well, our first position was that the law be changed so that a mistaken fact excuse cannot be applied where it's a sexual offence. And in fact, what we were asking for was not even really considered. What was actually proposed and I'll read this out in the bill. In deciding whether a belief of a person was honest and reasonable, regard may be had to anything the person said or did to ascertain whether the other person was giving consent to the act. Now, again, the effect of that proposed amendment is that really anything that the defendant did, no matter how inadequate, could actually be interpreted as well, firstly, doesn't necessarily need to be taken into consideration, firstly, and secondly, it could actually be wholly inadequate. So what we were asking for is, well, okay, if you are actually going to allow this excuse to apply in sexual offences, then at least make the defendant have to have a compelling evidence of reasonable steps that they took to determine consent. and that's the basis of their mistaken belief. So again, it's not, our position is that what we're asking for in terms of the amendment, if they are going to continue to allow the mistake of fact defence or excuse to apply, is, well, at least make the reliance on the mistake of fact based on something that the defendant's actually done, to go, well, this is why I thought the other person was consenting, because I asked, because I did some reasonable steps in terms of determining whether or not the other person was consenting. And that's the basis of my reasonable and honest mistake. Again, what we got was, well, you don't even really have to consider what the defendant did. And if you do, it can be based on really anything that they did. What we were asking for as well is that consent be completely, the word is vitiated, which means not relevant if there are injuries on the victim and on the victim's survivor. And again, this is not really radical. It's not a radical proposal that Women's Legal Service was asking for. What we're in effect saying is that if someone is alleged of a sexual offence and there are injuries on that person, then the defendant cannot rely on consent or mistaken belief as to consent, that the injuries in and of themselves actually mean that the mistaken belief excuse can't be relied upon, and in fact there cannot be a reliance on that, oh yes, we were doing this but it was with the other person's consent, or that I was mistaken as to consent. So it actually negates the opportunity to say that the victim survivor was consenting where there are injuries sustained. There is always in the criminal law different sliding scales of injuries, and certainly in other jurisdictions the injuries need to be grievous bodily harm. Again, you know, the fact is that the Queensland Law Reform Commission didn't engage with that, with our recommendations in relation to that at all. Another area that we were asking for an amendment to our existing law was in the circumstance where there is withdrawal of consent, and this is a circumstance where somebody is engaging in a particular part of a sexual act. And a really obvious one is, say for example, I'm going to use some anatomically correct terms here, so I'm just saying that in case people are uncomfortable with that. But let's say that a party consents to penetration by penis into their vagina. However, if that changes, so for example, let's say that becomes penis to anus, and the complainant, victim survivor, is not consenting to that, there was nothing in our existing law that really articulates that, look, the party who's changing or turning that act into or introducing a novel act really does need to check with the other party as to whether or not they're consenting to that new novel act. So again, you can see how, because that isn't actually a feature of our legislation, it's very easy to rely on mistake of fact defence for the defendant, where they go, well, you know, she was agreeing to X, Y, and Z, which is why I thought she was agreeing to this other novel part of the sexual act that I introduced. You know, especially if she froze, she did nothing. So again, we were arguing that it really, you know, our law should actually cover those situations. Now, it's important to keep in mind that because the Queensland Law Reform Commission did not suggest an affirmative model of consent, because they didn't include, if the person says or does nothing, then they're not consenting, then it means that proposal which the law reform suggested, which was if an act is done or continues after consent to the act is withdrawn by words or conduct, then the act is done or continues without consent. That, in our view, is again inadequate. It's inadequate because it actually expects somebody in that position to say or do something to say, stop doing this. I just think that that's really unrealistic. And for very good reason, people in that position would be frightened. It's much more likely that they would do nothing because they don't want to get injured, because they're scared. So again, we just don't see any of these recommendations of putting, actually making it safer, making it safer for potential survivors of sexual violence at all.
Indeed. And I think when we discuss it socially, it seems so obvious.
It
And
does.
whatever legislation we have, it's got to be able to be understood by the community, as well as being reflected in the law. And I guess where we're at with the bill currently is our service and a number of other advocates and services have called on the government to reject the bill in its entirety and in fact start again with a broad-based review, which is centering victim survivors and in the criminal justice process rather than such a defendant-centric approach. Just to wrap it up, Julie, for those people listening who want to take some action, have you got any tips or ideas that community members, if they're shocked by this and surprised that Queensland didn't choose the opportunity to introduce something that's going to be far more, 2020, what kind of things do you think people might do? What could they do in their own right as community members to...
Well, I think that now is the time, really, isn't it? Because we're coming up to an election. So people can write to their local member. They can write to the existing government and also people who are in opposition at the moment. They can, if they are able to get these issues into some kind of a public awareness campaign. So, from my point of view, that's media. That's always media, also social platforms, and also lobbying the government and lobbying their local member, because if they can actually get that on the agenda of the government, it means that the government will take it seriously, particularly if they think that it's important to their electorate. Can I just say, Di, it's really important to understand that the government's position up until just recently was that the Queensland Law Reform Commission had done a rigorous review, and really their position seemed to be something like, well, you're just unhappy with the recommendations because the recommendations aren't in line with what you wanted.
Yeah.
To some extent, that's a bit of a cop-out. And the reason why that's a cop-out is because what we were saying is that the response to sexual violence is inadequate, and it is inadequate because of these laws. Because these laws are known by the community and they're known by investigating police officers. And you and I both know, Di, that people turn up to the police and they will say, this is what happened to me, and no action is taken. There are no charges laid because at that very first port of call, those officers will say, you will not get a conviction. This is going to be what you said against what he said. This is going to be him saying, well, he thought you were consenting. So because this review does not take into consideration those overwhelming amount of incidences, it is an inadequate review.
Thank you. And look, thank you, Julie, for your comments today. I think it's been a really informative session. We appreciate the work that you do and we appreciate you joining us today. And I think it underlines that it's really important for us as feminists and advocates to continue to listen, believe and support victim survivors and keep our focus on addressing the injustices of sexual violence. And really, in order for transformative change, we need to educate and advocate as well as legislate. Legislation can't just sit on its own. So there is a role for all of us, as you've outlined. You can keep up to date on what we're doing on our website and our social media pages, on Women's Legal Service social media pages. And I'd just like to, I had a bit of a wrap up with something. I had a bit of an epiphany when I was looking last month at mistake of fact, when I was really considering women's reality in relation to it. And I thought, the reality really is the victim survivor is really the one who formed an honest but mistaken belief. The honest mistaken belief being that the offender was a safe person to be around.
Yes, that's correct.
And that's really what we're dealing with. We are dealing every day with women who believed that the person that assaulted them was going to be a safe person to be around. They weren't. And then they're facing the double whammy of the legislation then not going forward in the criminal justice system, perhaps not being taken seriously and perhaps not being believed. So I think we all need to join together with the Start by Believing. We need to keep advocating. Any change in law is, moves at glacial speed. And we need to be in for the long haul. And Julie and I have been in for the long haul and will continue to be that. And we ask all of you to join us in making sure that we can hold governments accountable, change legislation that's actually going to make victim survivors safer. Thank you.
Yeah, thank you very much.
Thank you.